The Honorable, the Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. And if you will, go ahead and call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Thomas Velde Jr., case number 23-8P358. Representing the appellant, the state of Vermont, is Nicholas Batty. Representing the appellee, Thomas Velde Jr., is Rebecca Turner.
Thanks very much. And good morning, counsel. We'll hear from appellant. First, of course, come on up if you would to the podium. We have a new podium. You can press a button somewhere on the other side and raise or lower it if you like.
Thank you, Justice. Although given that it's new, I don't want to be the person who breaks your podium. I'll not mess with you.
Okay. That's understood. If you would, please identify yourself and your client and then go ahead.
Yes, thank you. Good morning, Justices. May it please the court. My name is Nicholas Batty, bar number 6442. I am a deputy state attorney with the Rutland County State's Attorney's Office, and I represent appellant the state of Vermont. And before I begin argument, I would just like to briefly note that in the courtroom present today is Tammy Cabroni. She is the spouse of the deceased victim from the underlying criminal case.
Can you move the microphone a little closer? I'm having a little trouble hearing you. Thank you.
Yes, Justice.
Thank you.
The Civil Division erred when it granted summary judgment for the appellee and held that appellee's guilty pleas did not waive the non-jurisdictional defect that his habitually enhanced conviction and sentence included a faulty underlying predicate conviction. The Civil Division also erred when it vacated the sentence and remanded for resentencing to the Criminal Division.
So what would be the remedy if it's not a remand or resentencing?
I believe it would be a remand for a status conference where the state should have the opportunity, if it so choose, to withdraw from the plea agreement. That would restore the parties to their respective positions prior to entering into the plea agreement.
And do you think there's any dispute whatsoever about the validity of the 2009 change of plea that was done on the unlawful trespass?
No, it does appear that it was under this court's cases in Bridger and Stocks that it would not satisfy this court's precedent and rule that on a factual basis.
Would it have satisfied it in 2009 when it was done?
Good question, Justice Cohen. I haven't really thought about that deeply enough to consider whether or not it would have.
I mean, the standard has changed over the years as to what was required. Substantial compliance used to be the test. I was just wondering if you thought that that would even pass the substantial compliance test.
I think that would be tough to say that did or not. Thank you, Justice. Yeah, I'm trying to think. I think it would be tough to say that it did even then. I would have to look again at the exact plea colloquy from the 2009 unlawful trespass conviction. And not having it exactly in mind, I couldn't say. No. But my recollection was that the colloquy was essentially, does the affidavit provide a factual basis? But again, I wouldn't quote me on that. But I think it would be tough even on a 2009 standard. And so turning to the court's summary judgment decision, or the Civil Division summary judgment decision, it erred in sort of two interrelated ways, and I'll first sort of spell out both arguments briefly. First, the Civil Division erred in holding that In Re Gay, this court's decision for 2019, created a new rule for retroactivity purposes. Second, it also sort of interrelatedly erred in its analysis of the prior precedent to say that the law around waiver was unclear and in conflict at the time, which of course led to its holding there was a new rule.
And let's just be clear. We're not here talking about vacating the conviction, right? It's the enhancement is what we're talking about.
Yes, it is the habitually enhanced
right.
Convictions. which, understanding that habitual enhancement is not itself a separate offense, the case law is clear on that. It is in practical purposes an element of an offense when a state has to prove a principal crime, say either of the felonies in this case. After it's proved that, it is the state's burden to prove beyond reasonable doubt to a jury that the defendant is the person convicted of at least, the necessary predicate felony convictions.
But you're saying if you lose the enhancement, this shall all be unwound.
Yes, because from the state's position, that was a material breach of the plea agreement. In turning to the transcript of the plea colloquy, which, based on the record, it happened after evidence in the trial had already begun.
The 2018?
Yes, the 2018 plea agreement. The state quote, when discussing with the criminal division why both sides were in agreement with the plea, while the state feels confident in its case and feels confident that the jury would have returned a verdict of guilty on all counts, we're still able to argue for up to life imprisonment. So that was an important inducement to the state entering into the agreement and agreeing to dismiss a felony impeding conviction and a misdemeanor driving with a suspended license for DUI conviction, is that it still had the habitual enhancement to the two felonies which the defendant pled to.
So the sentence as it is currently, the 19 to life, if you didn't enhance it, would be an illegal sentence, would it not? The two charges that he pled to both have a maximum of 15 years.
Correct, Justice Collins.
So the maximum using consecutive sentences would be what, 15 to 30 be the maximum under if you didn't enhance?
The maximum would be 30 years on the two, yes. I suppose the minimum could be more than 15, but I think that's irrelevant. So as to the civil division's analysis, it erred in reviewing the case law and finding that there was a conflict or that the law was unclear as to waiver. Because, of course, the law on waiver in the specific context, which is challenging predicate convictions to an enhanced conviction when you've pled guilty, was clear for well over a decade before the appellee's plea in 2018. When a defendant pleads guilty to an enhanced crime, they waive the right to attack those necessary predicate convictions. That's Ray Torres, this court's unanimous published decision from 2004. That was the explicit question presented and resolved by this court in Torres. And until this court's sort of post-conviction trilogy in Reggae, Benoit, and Lewis, that central holding in Torres, from my review, does not appear to have been addressed in the published decision by this court. It was the law, and it was the case regarding the waiver consequences in this specific issue.
I know we didn't talk about waiver banning, but you don't disagree that factually it's kind of similar to this process.
It is similar factually in that it was a challenge to a predicate conviction, right? A challenge to a DUI-3 because the defendant, while facing a DUI-4, filed a post-conviction attack on a DUI-3 before they entered either into a plea agreement or convicted in Manning before that. So factually there's similarities, but it's also different because the defendant in Manning took affirmative actions to preserve their right to challenge the predicate conviction before reaching either agreement or being convicted of the enhanced conviction.
Right, it was a conviction, not a plea in Manning, right?
I understand that given the appellee's briefing, that there's been confusion about that. I believe the appellee asked this court to notice the docket from the underlying criminal conviction. I am not taking a position on whether or not this court judicially notices it. it may have been a plea. And so for the sake of argument, the state just assumed that Manning was a plea.
And should it matter whether that's a plea or whether that's a jury conviction? And how we analyze the case?
It should not. It should not, because Manning, again, was not a case about waiver. There's no discussion of waiver in Manning. There's no discussion of In re Torres in Manning. And the defendant took affirmative steps to preserve that exact challenge before, let's say, if we assume they pled guilty, by preserving it, by bringing a post-conviction challenge. That did not happen in Torres. Torres is about an unconditional guilty plea to an enhanced conviction that later they tried to undermine the enhanced conviction in the post-conviction proceeding by attacking the predicate convictions. And as this court recognized in re Gay, the distinction of whether or not the current challenge is about the enhanced sentence or conviction is not a distinction with a difference, a meaningful difference. In re Gay specifically rejected that exact challenge. And so, and if we just briefly looking through the civil divisions, the case that it was relying on and sort of seeing a conflict, there's Boskind from 2002, conditional plea agreement. Manning, again, an affirmative action to preserve the right to post-conviction challenge for the predicate. Mentioned Stocks and Bridger. Those are not cases involving waiver. Those are not cases, they do not mention Torres, nor do they have to do with predicate convictions. Those are about challenges to the knowing and voluntary nature of the plea itself, which there is no dispute from the parties that the plea of 2018 was a knowing and voluntary plea that complied with Rule 11. And so as this court noted, Benoit, there was no direct conflict. Right? That was the language used by Benoit. This court used very particular and precise language that you were harmonizing case law because there seemed to be practical potential conflict. But in terms of the holdings and when viewed through the lens of what is the law of waiver, there was no conflict. As to then from that error from the state's perspective, from the civil division, it then erred in its ruling on that In re Gay created a new rule for retroactivity purposes, based on this court's judgment this court's decision in re Barber. In re Gay was explicit that it was dictated. Its decision was dictated by Torres.
Do you think we can read Benoit retroactively?
So I'm not confusing the question, Justice. Read.
According to Judge Teachout, just so maybe I can clarify this, according to Judge Teachout, Benoit set the rule with the time and as to what the process is. Can we read that when that was 2020, this was a change of plea in 2018? Can we take Benoit and retroactively apply it to these facts?
To the extent that In re Benoit did not overrule any prior case law or did not change the requirements for preserving rights to make this post-conviction challenge, although I would say Benoit, what's new in Benoit is the specific procedures that this court ruled and identified for preservation, separate from what is the law of waiver. In re Gay is really the case that says, okay, In re Torres bars this challenge. In re Benoit is not new, certainly, as to waiver, and neither is In re Gay, but In re Gay is the first decision in the trilogy that sort of adopts In re Torres. And so if In re Gay says its decision is dictated by the holding in Torres, I don't see how under the retroactivity analysis in Barber, that is a new rule, because then that would mean every time this court takes holdings from prior cases, applies it to principally undistinguishable procedural and factual circumstance, that creates a new rule, then we're creating new rules for retroactivity purposes all the time. I believe I have some time left, so I will reserve my time.
Okay, all right, thank you very much. We'll hear from counsel for the appellee, please. Come on up and, if you would, identify yourself and your client for the record.
Thank you, Your Honor. Thank you, Your Highness. Good morning, Rebecca Turner for petitioner Mr. Velde, appellee here before this court. So just to clarify, having listened to the first part of argument, the issue before this court is extraordinarily narrow. The narrow question is whether or not the new rule established in In re Benoit and In re Gay applies retroactively to Mr. Velde. And what I have heard here during oral argument from the state is new, because in the briefing, the state declined to address those arguments directly. What I heard here on appeal is an acknowledgement that In re Benoit established a new procedural rule to preserve the ability to challenge collaterally an unlawful sentence after the conviction that relies on it to enhance the sentence in the PCR. And so now that's a significant concession. And I think that we have the answer to the narrow question, which is, did In re Benoit and In re Gay establish a new rule? And again, the significance of that question is that is the determinative question as to whether or not the new rule applies retroactively to Mr. Velde. And In re Barber,
But
a decision that
is the new rule that you're talking about, isn't it just a procedural rule? Isn't it just a, this is how you go about doing this challenge?
it is about how a petitioner can challenge an unlawful prior conviction that is being used to enhance a sentence based on inadequate 11F plea colloquy, right? And so it is a new rule regarding the defendant's right to challenge unlawful predicate convictions through PCR proceedings involving guilty pleas. That is the new rule. Now, as we heard about in the argument, as my briefing tried to make clear, In re Gay tries to reconcile the two lines of this court's case law that was in existence during Mr. Velde's change of plea, 2018. And there, In re Gay,
Mr. Chair, so how do we rectify Torres, which said that it can be, if it's done, we can look at Torres. And that's a 2004 case.
Mhm.
How do we factor that into this?
I think, Your Honor, that again, from the perspective, and this is, the court looks at it from the perspective in 2018, from Mr. Velde's position when he changed his plea, the state of the law at that time. Right? Because that's what In re Barber says, is that in PCR proceedings, the governing controlling law, you look at what is the valid law at the time. In re Torres was certainly in effect 2004, but also there was In re State v. Boskin, In re Collette in 08, Stocks 2014, Bridger in 2017, and of course Manning in 2016. In re Torres is the only one that the state is pointing to that suggests that the court established implicit waiver of collateral challenges in guilty pleas.
Except Gay, that's very recent, cited that with authority.
Yes, Your Honor. In re Gay, however, is a 2019 decision. So not until 2019 does the court clearly rule that a guilty plea involving a habitual offender sentencing enhancement that doesn't specifically preserve the right to challenge those underlying convictions waives the PCR challenge. Not until 2019, a year after Mr. Velde pled. And so that isn't the governing rule. In re Gay does rely on In re Torres and distinguishes In re Torres from In re Manning, which we have now shown and revealed that that was an artificial distinction because In re Manning, in fact, was a guilty plea, the same procedural posture as In re Torres, making that distinction now not significant.
Do you agree that in Manning, however, the defendant preserved the argument?
I think that the issue there in terms of whether or not the PCR was preserved, he had a co-occurring PCR petition filed, as I understand the proceedings. He did not preserve on the record at the time of his change of plea to the DUI-4 that he wanted to challenge this. And certainly, in Ray Torres, the one case the state points to in terms of this broad application that it holds that for all time, guilty pleas waive PCR challenges for sentencing enhancements, this court's opening paragraph of that decision says, on the ground at issue here, the PCR subsequent challenge is waived. Well, the ground at issue in Ray Torres wasn't a Rule 11F factual basis challenge, which Bridger, right, which in Ray Stocks, which in Ray Barber confirmed had been controlling law at the time of the 2009 plea, that a factual basis had to be admitted to make sure that the conviction was lawful or guilty plea. And Ray Torres was not challenging a PCR, I think it was a DUI-3 challenge there. It wasn't challenging it under, no, it was a domestic. It was an aggravated domestic.
Second, it was a felony domestic, right?
And the challenge there was that he was merely arrested, that there wasn't in fact an underlying conviction. So it wasn't an 11F. And on that ground, this court determined in Ray Torres that that waived it. Now, if you were Mr. Velde, this outlier of an Ray Torres decision, right, not dealing with a sentencing enhancement like a habitual, not dealing with a Rule 11F failure to admit, something sort of very, very like an aberration. Meanwhile, you have in Ray Stocks, in Ray Bridger, you have Manning, you have Colette, and you have Boskin, not at all making a distinction how the conviction came about. Jury trial, guilty plea. And in fact, we now know in Ray Manning was in fact a guilty plea. In Ray Colette, there was just a reference to convictions. I didn't have a chance to take a look at whether the actual docket below reveals it was a guilty plea. So back to the question before this court.
So there is a distinction between a change of plea and a guilty verdict from a jury in how we would analyze these.
This court determined that was a significant point in Ray Gay. And because of that significant point, the court created a new preservation rule in Ray Benoit, reconciling the tension, right? Requiring not just an affirmative statement, but requiring getting approval from the state in the context of the plea agreement, getting the court to accept it, identifying the specific conviction that you would challenge subsequently in the PCR, and establishing the grounds of the challenge. In no way can you find any of those pieces of the particularized requirement to make sure you protect your right to do a follow-up PCR in that earlier cases.
But isn't that just a natural, aren't those cases a natural flow from Torres, which said you can't challenge when you plead guilty? And then those cases say, well, yeah, I mean, they're really acknowledging that you can't challenge if you plead guilty unless you do this or this and the procedures set up. So don't those cases acknowledge the fact that it's good law that someone who has pled cannot challenge unless you do these other things? So how is that a new rule?
For purposes of the retroactivity question, a new rule doesn't require that the two lines of case law that this court recognized were in tension, lacked uniformity in application. It doesn't mean that you have to technically overrule those other cases. But certainly after in Ray Benoit and in Ray Gay, this court has reconciled and try to make sense after the fact how to harmonize those lines of cases. And that is for purposes of understanding whether a new rule exists under Teague, under Ray Barber. That's what is significant. And I do not hear the state disagreeing, nor could it. This court found in Ray Benoit, after extensive review of the two lines, that it was in fact intention, that it was in fact lacking uniformity, requiring a direction to the Criminal Rules Committee to establish a new rule under Rule 11A, 3 and 4 now, to clarify what it is, because it was not clear. And so for purposes of that application, the civil court's application of In Ray Barber is a straightforward interpretation of the new rule. I do not see how this court could find it was not a new rule in light of In Ray Benoit.
So would you speak to the,
I was going to ask about the remedy. I think you were going to ask the same,
yeah.
but
All right. Would you speak to the remedy here in terms of what happens if we agree with you? State says plea agreement comes unwound. You agree?
No, I do not agree. State is wrong for a few reasons. First and foremost, they forfeited that argument. This is the first time they've raised that argument. They never challenged the civil court. It was the remedy requested by Mr. Velde in these PCR proceedings. They filed a cross motion for summary judgment, never challenging that relief requested, and the judge imposed the relief requested. And so here on appeal, in the first instance, the state is asking this court to do something that it never asked the civil court to do. But not only just that, that it's forfeited under this court's precedent, it does not engage in the first instance, unless it's plain error. It is not plain error. And Ray Manning establishes just this, and Boskind, that it is not to, that a sentencing enhancement challenge should be done in a PCR. And again, you're challenging an underlying conviction where the person is not serving under sentence of DOC, so you can't challenge that conviction directly, as is the case here. The 2009 felony trespass at issue here has long been served. No jurisdiction.
So it'd go back to sentencing, to the sentencing judge without the enhanced habitual.
Yes, Your Honor.
And so with two charges of 15-year maxes.
Yes, Your Honor. That would be what is the appropriate remedy. That is what the civil court did here. And so it would just require affirmance, again, consistent with this court's case law, that is the remedy. That the challenge here is the unlawful underlying felony, as noticed in this docket at the time of arraignment, 2016, when the state filed the information and noticed that it was intending to go after the habitual offender enhancement punishment. It identified only three felonies, and this is one of them. And so, again, under this state's clear, this court's clear law, there wouldn't even be plain error if the court was tempted to engage in plain error analysis. Certainly not on this record. Was there any express condition that Mr. Velde couldn't pursue PCR challenge on the underlying? So there was no express breach of contract here that the state claims.
Leaving aside the waiver, can you tell me, you are changing the terms, a material term is no longer part of the sentencing agreement, it's part of the plea. How does that jive with our general view?
Your Honor, respectfully, this argument doesn't change the material terms. The material terms was for open sentencing where the court was free to impose any lawful sentence. And specifically, Mr. Velde asked the court to clarify, did that mean the court had to impose a life imprisonment sentence because of the habitual? And the court said no, that a lawful sentence included not imposing the life. So as understood at the time, the terms of the plea agreement and the change of plea in the sentencing were such that the state was prepared for this court to impose just a 15-year max or less even, because there is no requirement for the max to be imposed under these two counts. It could have been a sentence of 0 to 1 day if they were concurrent. And so the point is to highlight that the state is not there's no switch in terms of what the state understood it was pleading to at the time in 2018. If there are no other questions, I will sit down and.
Okay.
Thank you.
Thanks very much. How much time does the appellant have, please?
Appellant has 1 minute and 9 seconds remaining.
Counsel?
I will be brief then. The state wants to make very clear it is not conceding that either Benoit or Gay established new rules for retroactivity analysis. Yes, Benoit, this court established a new procedure that is separate from the question of retroactivity, which in Barber, is it a new rule if it overrules or significantly alters a prior decision, imposes a new obligation on the government? The result was not dictated by prior precedent at the time of the defendant's conviction became final or overturns prior precedent. None of those apply to Gay. Gay specifically says Torres dictates the outcome. How can that be a new rule regarding a waiver? It is explicitly relying on prior precedent that existed at the time of the plea, or at the time his conviction became final. Alternatively, regarding Remand, the state would believe, the state would argue this was plain error. It was obvious under contract principles. It affects the state's substantial, really fundamental right to try criminal defendants of all the charges it brings. And to uphold this error would seriously undermine the fairness of the proceeding by allowing the appellee to get the benefit of the plea agreement, then attack the plea agreement and undercut the plea agreement itself, and preclude the state from then being able to withdraw from the plea agreement, being restored to its original position, and proceed with prosecuting the case as originally charged and as it was prosecuted. This happened mid-trial, and the state did agree to dismiss a felony count.
Okay.
Thank you.
Thank you very much. Your time has expired.